I'll wait. Sean, I have BNP. I don't want to talk.
Okay, so looks like we've got everybody we'll need. We'll go ahead and get started. Sir, who's sitting there, would you please identify yourself first and last name?
Juan Castillo Pacheco.
Thank you, Mr. Pacheco. Mr. Pacheco, we're doing an initial appearance on today's date. You are being charged with drive-by shooting from a vehicle and aggravated assault with a deadly weapon. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and there is counsel seated next to you to assist you on today's date. In this matter, the state is recommending that bond be set in the amount of $500,000 with release to pretrial services if bond is posted. Any additional record from the state?
Your Honor, the state notes the defendant is 17, so he shouldn't have a pistol, much less use it. He shot at somebody from a moving vehicle, which is inherently incredibly dangerous. He struck another person while shooting and apparently already has a juvie record, was on release. And as far as parents willing to take custody, it's pretty clear by the fact that he's doing something like this, that the parents may have the desire to take custody and keep track of this person. They don't have the ability to do so. $500,000.
Mr. Poston, is the state requesting that Mr. Pacheco continue to be detained at the Adult Detention Center?
Yes, Your Honor.
All right.
This is an adult crime. He's on the cusp of adulthood. And under the rules, this sort of crime for this age of an individual does render him eligible for adult jail.
Okay. I'm going to have some questions that I'm going to pose first to the state and then second over to defense counsel. Then there are some factors we have to consider under ARS 8-305D. In the state's determination, what would be in the best interest of the juvenile charges and the other juveniles detained in the adult detention center relative to Mr. Pacheco being detained in the detention center versus juvenile detention?
Your Honor, this person would pose a danger to the individuals in the juvenile detention center because he has shown himself to be capable of committing the most dangerous kinds of crimes. But for the defendant's horrible marksmanship, we could be looking at a murder charge here. And therefore, he poses a danger to the other children who may be looking at less dangerous charges, who may be inherently less dangerous. This person poses a risk.
And then does the state agree that the defendant is currently 17 years of age?
Yes.
Does the state have any information regarding the physical and mental maturity of the defendant?
No.
And does the defendant pose any or appear to be suffering from any sort of mental distress that would make it likely that imminent risk of harm would occur to Mr. Pacheco if he remains at the detention center?
I have no such information, Judge.
Are the nature and circumstances of the offense as set forth in the recommendation from the state?
I beg your pardon?
Are the nature and circumstances of the offense as set forth in the recommendation from the state as well as in the complaint?
All the information has been given to the court to the best of my information, Your Honor.
In review of Mr. Pacheco's history, does he have any prior delinquency history?
He does have one prior. I will pull it up once more, Your Honor. Bear with me. Your Honor, I see that he has a conviction on February 7th, 2013 for possessing a narcotic drug for sale, for which he was placed on probation. Date of arrest 12/14/2022.
When you say 2013, do you mean 2023?
Forgive me, Your Honor. Yes.
Okay, going down the list. Will the Does the state have any position as to the ability of the juvenile detention facilities versus the adult detention facilities to meet Mr. Pacheco's specific needs and protect the safety of the public and detained juveniles?
Your Honor, it is the state's understanding that the Pima County Adult Detention Facility has a floor or a tier that is entirely devoted to those under the age of 18. And given the fact that this person has demonstrated the capacity to engage in activities that could have taken a life, it is in the best interests of the state to and the defendant and the other individuals in the juvie facility that he be in the adult facility to protect those younger individuals, and he will be protected from the adult offenders in the jail.
And then regarding existing programs and facilities for juveniles at both the juvenile detention center and adult facility, any input on that factor?
Your Honor, the state has no direct information as far as those factors go.
Are there any other factors relevant to this determination regarding detention that the state wants to address?
Just an emphasis on the fact this individual has demonstrated the capacity to act in such a way so as to cause imminent risk of death to an innocent bystander. Therefore, it is in the best interest of all those concerned to put this individual into the adult detention facility. This could have been a murder. This was incredibly dangerous. This is not child's play. This is an adult crime.
Okay, thank you, Mr. Poston. For the defense, let me first hear about your record on behalf of the defendant, then I'm going to go down the list of factors. Go ahead, sir.
Yes, Your Honor. We would ask that a lower bond be set than the $500,000 the state is recommending. We would add that Juan here is a lifelong resident of Tucson. He is a full-time student, as Mr. Poston noted, and obviously is an age of 17 years old. Additionally, Juan does have stable housing. He has family support that he can turn to. And given his age, a $500,000 amount would be paramount to a no bond hold. There's likely not a bond that he'd be willing to pay or able to pay himself. And I'm not sure what the financial means of his parents are, but I would presume that $500,000 is tantamount to a no bond.
And going down the list as far as whether that any detention that's going to occur would occur at the adult detention center or at the juvenile detention center. Let's go ahead and go down the list of factors. So the first factor being the best interest of both the juvenile charges as an adult and the other juveniles detained in the adult detention center. Any record on that factor?
Your Honor, I would ask that he be held in the juvenile detention center. I would note that he doesn't pose any physical risk face to face with any individual. There's nothing to insinuate that outside of gun violence, he is a personally violent person. I don't believe that he would be a risk to juveniles in the detention center.
And then as to the second factor, the juvenile's age, any record?
Your Honor, he's 17 years old. That is as far as record as I can.
Okay. As to the physical and mental maturity of the juvenile, any record?
I speak with Bill for a moment.
Sure.
Your Honor, no record for any outstanding conditions. He is in school. He is a standard straight-laced student in school. That's it, as far as records I have.
And then as to the juvenile's present mental state, including whether the juvenile presents an imminent risk of harm to the juvenile himself, any record?
No record, Your Honor. I do not believe that he represents him.
As to the nature and circumstances of the alleged offense, any record?
Your Honor, these charges are obviously, they are of a violent nature and they are of a concerning nature. I don't think that alone means that they are of a repetitive nature, that he represents an enhanced threat to the community as a product of these charges, given the context.
As the juvenile history of prior delinquent acts, any record?
He does have one prior delinquent arrest that was discussed by the state.
And as to the relative ability of the available adult and juvenile detention facilities to meet juvenile specific needs to protect the safety of the public as well as other detained juveniles. Any record?
Your Honor, I would once again highlight that I do believe the Juvenile Detention Center would be fully capable of housing and supporting one. I do not believe that the Adult Detention Center would be able to provide him the specialized care he needs as a 17-year-old student.
As to it's a similar factor, but the existing programs and facilities for juveniles at both the juvenile detention and adult facility, any record?
Your Honor, it is my belief, I can't say with certainty, but it's my belief that the Juvenile Detention Center is better fit for a full-time high school student to attain the level of care and necessities that he will need.
And then if any other factor relevant to the determination of where to detain the juvenile, any additional record?
No.
Okay. So the court has reviewed the interim complaint. The court has reviewed the pretrial services report provided by pretrial services. The court has also considered statements from both the state and the defense, has reviewed the initial appearance recommendation by the state, and has further heard argument as to the relevant factors under 8-305D. The court finds as follows pursuant to 8-305D. Court finds under factor 1 that as to the best interests of both the juvenile charges as an adult and the other juveniles detained in the adult detention center, the court finds that while the nature of the instant offense does not necessarily affect the safety of other juveniles in excuse me, let me make sure I'm reading this properly. The court finds that there's no aspect of these instant charges that affects the best interests of the juvenile charges as an adult and the other juveniles detained in the adult detention center. As to factor 2, the court finds that the juvenile is 17 years of age. As to factor 3, the court finds that there are no circumstances regarding physical or mental maturity which directly impact these findings, except that the court is not presented with any indication that the juvenile lacks the physical mental maturity typically associated with a 17-year-old. Court finds under factor 4 that there are no circumstances as to the juvenile's present mental state suggesting an imminent risk of harm that guide the detention decision. So factor 5, the court finds that the nature and circumstances of the offense included alleged use of a firearm causing physical injury to a member of the community. Court also finds that the other circumstances regarding the allegations suggest that the use of a firearm was not done entirely without provocation. Court finds that in factor 6 that there is a prior history of delinquent acts, which the court will not detail specifically out of privacy for the juvenile, but which suggests that the juvenile detention facility is inappropriate. Court find based upon the propensity for recurrent acts to be that would impact other juveniles at the juvenile detention center. Under factor 7, the court finds that there are no special needs of the juvenile which have been identified, which cannot be met at either an adult or juvenile detention facility. The court finds that the safety of the public would be equally protected at either facility, but based upon the prior delinquent acts from factor 6, that it would be protect the safety of other detained juveniles not to have the defendant at a juvenile detention facility. Under factor 8, the court finds that the existing programs and facilities at either detention facility are immaterial to this determination. And finally, the court, as to any other factor relevant to the determination of where to detain, the court observes that the nature of the offense is serious. It resulted in the injury of a member of the public who was not directly involved in the circumstances leading to the alleged use of a firearm. Additionally, the court, based upon the circumstances and all of the record before the court is ordered at this time setting bond in the amount of $100,000 cash is secured with release to pretrial services if bond is posted. Additional conditions of release: no alcohol or illegal drugs, no firearms or weapons. Any firearms or weapons in the possession of the defendant shall be surrendered to local law enforcement. the defendant shall follow monitoring or treatment directed by pretrial services. No contact with the alleged victim. Do not go back to the incident location. Court will appoint the Pima County Legal Defender's Office to represent the defendant. A preliminary hearing is set for the defendant, July 14, 2025, 1:30 p.m. And if not already stated, the court will indicate as well as that the defendant shall remain detained at the Pima County Adult Detention Center. And the reduction of bond from the recommendation is also based upon the circumstances presented in the interim complaint, which, as the court indicated, suggests there may have been provocation that caused the use, but nonetheless, the use of a firearm is in this manner was alleged use of a firearm was serious enough that merits ongoing bond in order to protect the community. Okay, so we have the next court dates. Any questions, Mr. Pacheco, before we conclude?
No, sir.
Okay, then you're excused. Thank you, sir.
Mr. Pickens, this is for you. Mr. Ronnie, on expert day. Somebody can get to see the Saturday.
Oh, I've been making sure now. Yes.
Yeah.
Huh? Oh. You're right.
Okay.
You're all interesting.
She's not looking for you. Isn't he missing?
He's representing you this morning because they have a post-taxer that has to represent you.
It's a misdemeanor.
It's a misdemeanor. He's not gonna help you. I'm cleanest.
Yes, I.
Just tell her that they won't stick.
Just tell them that you don't want to just, that's why you're saying. How will you?
Judges are always trained to say, "Hey, this is what I want to do."
Come on, just take
This is a Superior Court judge.
a superior.
They do the initial appearance. I don't know, Steve, why don't you see it and they'll tell you, we don't want you there.
I don't like to be told anything.
Well, then we just tell him.
Just go take a seat. You're already here.
Olsen, come on. Tell me real quick. Come on.
That's he's a dead boy. So when
Your Honor, Olson's refusing to sit in front of you.
Mr. Olson's refusing to appear.
Yeah, thanks.
Angela.
It's a second refusal.
That it's given that the defendant is refusing to appear on today's date. At this time, the court will order continuing the initial appearance for Mr. Olson to this evening.
But thank you, Your Honor.
Thank you. Moment to get this processed out. Good morning, ma'am. Can you state your name, please?
Angela Pruitt,
Pruitt, I don't know if you remember me. but I used to represent you as an attorney a long time ago.
I remember you.
Yeah.
Yes.
And so because of that, first of all, Ms. Pruitt, good to see you again. Second, because I used to represent you as an attorney, that creates what's called an ethical conflict of interest for me to conduct your initial appearance today. Because
Okay.
whether I release you or don't release you, it could be seen as me giving you favorable treatment or not unfavorable treatment. So what the
Okay.
court has to do, unfortunately, is to continue your initial appearance to this evening. So that's what the court's going to be doing today. Do you have any questions about that?
No, I understand.
I hope things go well for you in the future. And unfortunately, I just can't proceed on your case and you are excused
All
from
right.
time. Thank you, ma'am.
All right, thank you.
So that if not previously stated, the court will order continuing the initial appearance for the defendant to this evening.
So. Yes. Yeah. There's something that's kind of he's here now. Oh, no, that's what you get the situation. He's pretty here, so. Oh, yeah. Alright,
Yeah. Go around. Go around. You guys are gonna sit over.
Good morning, sir. Can you state your name, please? Getting a lot of noise. Can we try to cut down on the noise, please? I can't hear what people are saying. Thank you very much. Sir, can you state your first and last name?
Andrew Saunders.
Mr. Saunders, we're seeing you today for an initial appearance. Your charge on today's date is a charge of disorderly conduct, which is a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. Before the court proceeds further, I understand that we may have a stated victim in the case. Is there someone in the courtroom for Mr. Saunders? Hi, ma'am. If you please come up to the front of the courtroom and go to the defendant desk there, we'll have you just make your statement from there. Okay, and so if you would just indulge the court and lower the microphone down towards you, ma'am, would you identify yourself first and last name? Okay, so Mr. Rivera, what would you like to tell the court? Okay, and that's as to Mr. Saunders? And how do you know Mr. Saunders? Okay. Do you have any objection to him being released on today's date? Okay. And as far as his ongoing contact with you, do you have any, do you object to having ongoing contact or do you want him to have no contact? Okay. Anything else that you want to tell the court on today's date?
Okay, or
Okay. Anything else that you want to tell the court? I'm going to ask Mr. Saunders something really quick, but anything else? Okay, thank you for providing that input today. If you have nothing else that you want to say, you are welcome to go back to the gallery. I appreciate your input. Mr. Saunders, really quick, if the court was to what's called release you on your promise to appear, do you promise to appear at future court proceedings?
Yep.
Okay. This time the court will order releasing the defendant on his promise to appear. However, there will be some conditions of release: no alcohol or illegal drugs, no acts of domestic violence, and no firearms or weapons. You have a out of custody arraignment that will be set at the Pima County Justice Court. That is July 14, 2025, 10:30 a.m. If you do not appear at that hearing, then a warrant may be issued for your arrest. And do you have any questions at this time, Mr. Saunders?
just a copy of the paper so I can remember what day I'm there.
I believe that the individual sitting next to you will provide you with a copy of some paperwork, but just to repeat that, July 14 at 10:30 at the Justice Court downtown.
Okay,
Okay, thank you, sir. You're excused.
thank you.
Duran.
Okay, good morning, sir. Can you state your name, please?
Yeah, my name's Andy Reagan.
Hey, Mr. Duran, give me one moment. We're conducting what's called an initial appearance on today's date. You have a couple of charges before the court, essentially for failure to appear for some offenses back in 2023. These are misdemeanor offenses for drug paraphernalia and criminal trespass. You do have a right to remain silent. Anything you say can and will be used against you. If the court was to release you on today's date and have you appear at future proceedings, do you promise to appear at future proceedings?
Yes.
You understand that if you do not appear at future proceedings, that another warrant could be issued, and then the next judge who sees you may not be as lenient?
Yeah.
Okay. At this time, the court on these failures to appear, the court will order releasing the defendant on his promise to appear. As conditions of release, the defendant shall not possess or consume any alcoholic beverages or illegal drugs and shall not return back to any incident location. Additionally, any prior release conditions are affirmed. Next court date for Mr. Duran will be July 31st, 2025. That's at 9:00 a.m. at the city court for a pretrial hearing with Judge Bond. So make sure that you appear July 31st at 9:00 a.m. If you do not appear, a warrant could issue for your arrest. Okay, Mr. Duran?
Okay, thank you.
And you're excused. Thank you.
Your Honor, we have a superior court hold down for Duran.
Oh, you know what, Mr. Duran, why don't we have you come back, please? Sorry about that. So a little bit of an adjustment on the orders. It appears that there's a superior court hold, which means that there's an active case with the superior court, which prevents you from being released on today's date until that issue is resolved. So in light of that, even if I was to order you to be released today, the superior court has directed that the jail not release you. So in order to give you time served on any, I'm still going to order that you be released, except that you're not actually going to be released. So I'm not going to institute any additional bond. It's just that you are going to remain incarcerated at the Pima County Jail until there's movement on that superior court issue. Okay.
Okay.
Okay. So same orders, but since you're going to be in custody, I'm going to change your court date because I don't know when you're going to be able to get out. So let me do that really quick. All right. So given that you're going to remain in custody for the time being, you're going to have what's called a video review with the city court. That's going to be July 11, 2025, 1:45 p.m. That will be also with Judge Bond. And so instead of July 31st, you have July 11, 1:45 p.m. for video review. Okay, sir?
Okay.
All right, then you're excused. Thank you.
Sure.
Oh, yeah, and the court will also appoint the city public defender's office.
Oh, sorry. Yeah, sorry.
Yes.
Okay, good morning. Can you state your name, please?
Good morning, Your Honor. My name is Justin Daniel Majo.
Okay, Mr. Majo, let me confirm something before we proceed. Is there a hold on Mr. Majo right now, jail? No hold? Okay, just want to make sure. Mr. Majo, we're doing an initial appearance for you today on 2 charges of disorderly conduct and assault, which are domestic violence offenses and are also misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. I do believe that we have before we proceed, we do have a victim in the matter who's present. Do we have a victim here on Teams?
Yes, ma'am. Or sir, sorry, excuse me, I'm sick.
That's fine. And so, ma'am, would you just go ahead and identify yourself, please?
My name is Caitlin Estera.
And Caitlin, what would you like to tell the court?
Just any information that I can help provide you. I do believe that I know for a fact he was drinking yesterday, a few hours ago, and I do know that his behavior does vary when he does drink, which is due he does suffer with depression, so he can get very depressed, or he can get very irritable and such. I know that for a fact. I know he does struggle with his mental health. I tried to help him when I was in a relationship with him, and I'm not trying to cover up for him or anything. I just feel like maybe some of this was caused by some alcohol that was from yesterday. I still have a lot of bruising on my legs. A lot of it is on my back of my legs, which you may or may not be able to see those pictures I had turned in the other day. As a result of everything that happened, my scooter that he did hold from me is damaged. I have to go get new brakes and repair it. He has taken an item of mine, but I will let him have that. I can replace it easy. Yesterday, he did hold me hostage. I call it being held hostage because he blocked the door for me. I was not able to leave. I was scared. I have pseudo seizures, and I did have one on the floor because I couldn't breathe. And the reason all of it happened was due to I wanted to be left alone and wanted to go for a ride around the area due to kind of trying to, catch my mind up, kind of take a breather for a moment.
And Ms. Esterak, would you tell the court, do you have any position on whether Mr. Majo should be released today?
I believe he should be released, but I do not want any contact with him. I feel that he will hurt me and has hurt me. I think he deserves to have a chance. I do see potential in his future if he takes care of his behavioral health and kind of controls his drinking more. He is on probation, yes, but he's very hardworking and does day labor, and he's working on his dream of opening his own business. So I don't want to stop him from that, but I do ask no contact.
Okay, thank you, Ms. Esterak. At this time, Mr. Majo, the court will order that you be released on today's date on your promise to appear at future proceedings. However, there are going to be numerous conditions of release. You're not to use or possess any alcoholic beverages or illegal drugs. You're to commit no further acts of domestic violence, not to possess any firearms or weapons, no contact of any kind with the victim, Caitlin Esterak. You're not to go to her residence or workplace. And you're also to obtain a behavioral health and a substance abuse assessment from a community agency. The court will set your next hearing August 5th, 2025, 1:30 p.m. at the Tucson City Court with Judge Million. Make sure that you appear at that hearing. Failure to appear could result in a warrant being issued for your arrest. Do you have any questions about these orders before we conclude?
No, Your Honor. And I do have one question. I do use recreational marijuana. Would that count as something I can't use? Because it helps me go to sleep and helps with my anxiety and stuff. I don't know how that works. Am I prohibited from using that also?
The current orders are not to use alcohol or illegal drugs if the substance that you're referring to is legal under our current statutes, then that would not violate the order.
Yes, sir. Yeah, I go to the dispensary. I only get from the dispensary. So.
Okay. Any other questions before we conclude?
No, Your Honor.
Okay, you're excused then. Thank you, sir. And
No, Your Honor.
thank you, Ms. Esterak. You're
Yes, sir.
excused. Thank you.
All right.
Good morning, ma'am. Can you state your name, please?
Ashley Garber.
Ms. Garber, you're charged today with 3 counts of misdemeanor domestic violence for assault, disorderly conduct, and criminal damage. You do have a right to remain silent. Anything you say can and will be used against you. Just one moment as I take a look at one thing. Okay. In review of the complaint or the citation before the court and the probable cause statement in therein, as well as input from pretrial services, the court will order at this time that you're to be released on today's date on your promise to appear at future proceedings. However, there are conditions of release that you must abide by, or else you may be cause a violation and you might be reincarcerated. So these conditions include not to possess or consume any alcohol or illegal drugs, commit no further acts of domestic violence, possess no firearms or weapons. At the present time, I'm going to order that you not have any contact with Mr. Andrew Garber, the adult named Andrew. Additionally, you're not to go to his residence or workplace. Do you share a residence with him, or is it a separate residence?
It's a shared residence. I'm working on removing myself from there.
Okay.
Like right.
Then the court then will order that you can return one time to that residence with law enforcement to retrieve any personal belongings. Next court date for you will be an arraignment that's set with Judge Millian at the Tucson City Court. That will be August 5th, 2025, 1:30 p.m. Do you have any questions about these orders?
No, Your Honor.
Okay, then you're excused. Thank you, ma'am.
Thank you.
Oh, right, that one was for one of the previous ones. Sorry. Good morning. Can you state your name, please?
Michael Malley.
Okay, so we have you today, Mr. Malley, on an initial appearance for some failures to appear for some prior disorderly conduct offenses occurring in 2022. You have a right to remain silent. Anything you say can and will be used against you.
I'm the one who called the police. The initial one. I don't understand.
What I'll say, Mr. Malley, is that you have the court, based on all the information I'm looking at, the court intends to be releasing you on today's date anyways, but you'll have future court hearings where you can address any defenses to the charges. So at this time, the court is going to order that you be released on your promise to appear at future proceedings. The court will affirm any prior release conditions, and the court will set a hearing with Judge Cranshaw. That'll be for a pretrial hearing, August 4th, 2025, 2:30 p.m. at the city court. Make sure that you appear at that hearing, August 4th, 2025 at 2:30 p.m. with Judge Cranshaw at city court, or a warrant could issue for your arrest. Do you have any questions, sir?
No.
Okay, then you're excused. Thank you.
Your Honor, we have a Superior Court hold for Mr. Malley.
Oh, we do. Okay, so a little bit of a different configuration. The court is not going to be ordering any additional bond in this matter as to the city court charges for failure to appear, but your court date's actually going to be bumped up, Mr. Malley. So that's instead of being August 4th, it's actually going to be July 11, 2025 at 1:45 p.m. And that'll also be with Judge Cranshaw. So that's July 11, 2025, 1:45 p.m. So
I don't understand what it's like the court game.
So there's what's called a Superior Court hold. There's been some sort of case or involvement with the Superior Court where they have placed an administrative hold to where they do not consent to you being released from custody. So you'll stay incarcerated until that matter is resolved, and your next hearing date will be July 11 for the city court charges only. I don't have any other information about the Superior Court charges. I couldn't answer any questions for you about that at this time.
So they don't understand it. They stopped, they told me they didn't have to see the PO or nothing anymore. They lost my leg and stuff. And it's like 3 years later, they're bringing it up, and I had no going for nothing. So
if you are on probation, then I suspect that probation will be in contact with you, and or they'll file a petition to revoke probation. I just don't have any of that information right now, so unfortunately, sir, I can't give you any additional information on that. But based on the circumstances, you will remain incarcerated. The court will appoint, however, because you are remaining incarcerated, the Pima County Public Defender's Office to assist you, and because of that, the court will provide you an opportunity to talk further with them as well about your, okay?
well, they about my dog and stuff, and I don't have nobody to take care of my dog.
I would suggest speaking with your assigned public defender to see if arrangements can be made, but unfortunately, that's all the information I can provide. You're excused. Thank you, sir. Yes, please. Good morning, sir. Can you state your name, please?
Eduardo Mercado.
Okay, Mr. I show that your true name is Mercado Munoz. Is that correct?
Yes, Eduardo Antonio Mercado Munoz.
Excellent. So, sir, we have you here today on an initial appearance for 2 counts of disorderly conduct as well as domestic violence charge regarding surveillance or stalking. You do have a right to remain silent. Anything you say can and will be used against you. Let me see if we have we don't. So in review of the complaint, the probable cause statement, and information from pretrial services, the court will order as follows. The court will order that you be released on your promise to appear at future court proceedings. Court will order as conditions of release that you not commit any acts of domestic violence, no contact of any kind with the individual Estella, Lopez, not to go to her workplace or residence, and additionally that you're to stay at least 1,000 feet from the victim at all times. Court will set as your next court date a arraignment that will occur on August 5th, 2025, 1:30 p.m. with Judge Millian at the City Court. Make sure that you appear at that hearing, August 5th, 2025, 1:30 p.m. If you do not, and that's at City Court, failure to appear could result in a warrant being issued. Does that make sense?
Yes.
Okay, otherwise you're excused. Thank you, sir.
Thank you.
Nanz?
Okay, can you please state your name, sir?
Eli Anthony Nanez.
Thank you, Mr. Nanez. Can we check to see, is there a hold on Mr. Nanez anywhere?
No, there's not.
Okay. Mr. Nanez, we have a couple of misdemeanor offenses you're being seen on today. Criminal damage and disorderly conduct. You do have a right to remain silent. Anything you say can and will be used against you. In review of the probable cause statement in the citation, as well as recommendations from pretrial services, the court will order that you be released on today's date on your promise to appear at future proceedings. There are going to be some conditions of release: not to possess or consume any alcohol or illegal drugs, commit no acts of domestic violence, possess no firearms or weapons, no contact of any kind with any alleged victims, and do not go back to the incident location. Next court date for you will be at the City Court, August 5th, 2025, 9:30 a.m. For a pretrial hearing with Judge Bond. Make sure that you appear at that hearing August 5th, 2025. If you do not, a warrant could issue for your arrest. Do you have any questions, sir?
No, Your Honor. Thank you.
You're welcome. You're excused.
Thank you.
Oh.
And but while we're waiting on the next one, does the next Ms. Ramirez have a felony hold?
Yes, Your Honor, Ramirez does have a superior court hold.
Okay, thank you. Ma'am, would you state your name, please?
Betsy Ramirez.
Okay, thank you, Mr. Ramirez. You're being seen today on a count of criminal damage. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right, in looking at the information before the court, which includes the probable cause statement, the pretrial services recommendations, and also noting that you have what's called a superior court hold on you is at this time. What the court's going to do at this time is the court is going to order on these specific charges that you be released. However, because there's a superior court hold that's in effect, you aren't able to be actually released from custody until that issue is resolved. That might be because you have a probation case or something to that effect. So your next court date in this matter is going to be on this criminal damage charge. It's a video review. It's going to be July 11, 2025, 9:00 a.m. Excuse me, let me double check something really quick. Yeah, that's July 11, 2025, 9:00 a.m. For a video review at the City Court with Judge Hale. You'll review the status of the criminal damage charge, and then you'll be able to be released from incarceration once the hold is cleared with the Superior Court. But I don't have any other information at this time on that. The court will appoint the City Public Defender's Office to represent you since you are being held. Any questions for the court at this time? Yes. There's no hold on her. So there is not a Superior Court hold on Mr. Ramirez?
No, there isn't, Your Honor.
Okay, in that case then, a little bit of different outcome for today, Mr. Ramirez. The court is going to order that you be released on your promise to appear, and the court was going to set a different court hearing for you. You are going to be released today then. So let me just make some adjustments to the orders today, and then we'll get you on your way. Okay, so the court will vacate its order then appointing the city public defender's office. The court will order then again releasing the defendant on her promise to appear at future proceedings. Court is going to order, however, that she's not to go back to the incident location. The incident location where this alleged event happened, was that somewhere where you live, or was it just somebody else's house?
It's somewhere where I lived.
Okay, and so then until this is modified, the court will order that you can return one time with law enforcement to retrieve any personal belongings. If you need to adjust this order not to go back to the incident location, then you'll be able to pursue that with your criminal case at the city court. Otherwise, your next court hearing is going to be August 7, 2025, 9:00 a.m. Let me just take a look at something really quick before we finalize everything. Do you have any questions, ma'am, at this time?
No, I do not.
In general, just make sure you appear at your next court date, August 7 at 9:00 a.m. at city court. Failure to appear could result in a warrant being issued, okay?
Okay, thank you.
Thank you, ma'am.
Stevens, go on.
Okay, good morning, sir. Would you state your name, please?
Yeah, Trevor Stevens.
Mr. Stevens, you're being seen today on 5 counts of disorderly conduct, misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. As it happens to be, I believe I did a contested order of protection hearing with you and the defendant, or your former partner. So
Yes, sir, we did.
I am familiar with your case for separate reasons. I've also read the probable cause statement before the court, and additionally input from pretrial services. Based upon all of that, at this time, the court is going to order that you be released on these charges on your promise to appear. You're, however, ordered not to commit any further acts of domestic violence, and as well, any contact with the victim in this matter shall be only as permitted under existing court orders. So if there is still an order of protection in place, just make sure to follow that order of protection. Do you have any questions about these orders so far?
No.
At this point, then, the court is going to set as your next hearing an out of custody arraignment. That is going to be August 5th, 2025, 1:30 p.m. And that will be with Judge Million at the city court.
Okay.
That'll be your next court hearing in this matter. Make sure that you appear at that hearing. Failure to appear could result in a warrant being issued for your arrest. Do you have any questions before we conclude?
Am I gonna get released with paperwork that has those dates written on it, or?
Yes, you should receive that right now from the gentleman sitting next to you. And then
Perfect.
you'll have any additional paperwork when you get released, okay?
He's got it written.
Yes, Your Honor. Can you one more time repeat the date?
Yeah, August 5th, 2025, 1:30 p.m. with Judge Million.
Thank you.
Okay, you're excused, sir. Thank you.
Thank you.
Good morning. Can you state your name, please?
Kenny, Kelly, Megan.
I'm sorry, can you provide your name again?
Kelly McKinney.
Okay, thank you. Okay, we have you a little bit down the list. Sorry about that.
Oh, no worries.
So, Ms. McKinney, we have you here today. Looks like you were picked up on a warrant for failure to appear that was issued back on April 2nd, 2025. In review of the court file and other information presented to the court at this time, in order to secure your appearance at the next hearing, is going to order setting bond in the amount of $500 cash and secured. Court will order a video review to be held July 10, 2025, 1:45 p.m. And the city public defender is appointed to represent you. So hopefully you'll be able to wrap up anything that's before the court on July 10, 2025 even if you postpone, you are still to show up for that hearing to make sure a warrant is not issued again. Do you have any questions at this time?
Yes, sir, because I was in court on Monday and so I didn't even know that there was a warrant from a previous failure to appear. And I have court again next week. Again.
Which court did you have it in?
I'm in Compass Court and I had this past Monday. I've been there last Monday and this Monday, sir.
Which judge are you going to see next Monday?
Judge Burning.
Okay.
And I have a dentist appointment tomorrow that I've been waiting for forever. It's at 1 o'clock. If there's any way, please, sir, like I've been working really hard.
Give me one moment just to take a look at the court file.
Thank you.
You said which judge again?
Judge Burning in Compass Court. Yeah, I was there last Monday and I was there this past Monday, 2 days ago, and then I have court Monday again. And I have an appointment at CBI as well on Monday.
Okay. If we have, I'll give you a chance, Ms. McKinney, but if you do not show up,
okay,
then a warrant's going to issue again. The next judge who sees it may not be as lenient, okay?
Okay, yes, sir. I really appreciate you.
So what the court
Thank
will
you
then,
so much.
the court will, based on the circumstances provided to the court on today's date, the court will order releasing the defendant on her promise to appear. That would be a promise to appear at the August 5th, 2025, 9 o'clock a.m. Hearing. That'll be with, I believe it's Judge Blue.
Okay.
At the city court. Give me a moment to amend your paperwork here.
Okay.
The court will, under the circumstances, the court will not appoint, the court will vacate the order appointing the city public defender's office for the time being. However, Ms. McKinney, it's crucial that you go to this hearing on August 5th, 2025. If you do not appear, there is an extensive court file here, but the court, on your assurances that things are going in a positive direction, is going to give you a chance here, okay?
Thank you, sir. I really, really appreciate you.
And if you do not appear at future proceedings again, it's going to be somebody else who makes that determination. It's likely they will not be as lenient, okay?
Okay, thank you.
Let me just go ahead and get the paperwork finalized before we release you on today's dates. Just your trial. Do you have any questions about where you need to be or any of those things?
No, I don't. So you said August 5th?
August 5th, 2025, 9 o'clock a.m. with Judge Blue at the city court.
Okay.
Okay, with that then, you are excused. Thank you, ma'am.
Thank you, sir.
Good morning, sir. Can you state your name, please?
Jose Ramirez Miranda.
Thank you, Mr. Miranda. We've got you here today on felony charges of aggravated shoplifting, organized retail theft, and theft. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There's counsel seated next to you. The state is recommending bond be set in the amount of $7,500 plus release to pretrial services thereafter. Does the state have any additional recommendations?
No, Your Honor. State submits.
And then for the defense?
Yes, Your Honor. We just add this is a nonviolent offense. There was no flag. Mr. Miranda is a lifelong resident of Tucson, does have stable housing and employment. He also has a his last felony was in 2017. He did just inform me that he is currently battling colon cancer. And so for all those reasons, we would ask for a release to pretrial services, or in the, or
In light of all the circumstances, including those specific to Mr. Miranda, the court will order at this time setting bond in the amount of $2,500 cash and secured with release to pretrial services. The bond is posted. Mr. Miranda shall follow monitoring and treatment as directed by pretrial services and shall not go back to the incident location. Counsel will be appointed, the Pima County Public Defender's Office. Next hearing for Mr. Miranda will be a preliminary hearing, July 14, 2025, 1:30 p.m. at the Justice Court. Mr. Miranda, please make sure that you appear. If you're able to post bond and you're out of custody, you still need to go to that preliminary hearing, July 14, 2025 at 1:30 p.m. at the Justice Court. Any questions before we conclude?
Yes, I'm not working. Like I said, I'm battling cancer right now. There's no way I could post a bond. I mean, I'm by myself. I'm struggling, and right now I'm just fighting for my life. And there's no way I could post bond. And I do. I have I already had 2 surgeries, and I'm fighting for my life, Your Honor. You know what I mean? And I do have to. I have appointments. I have labs to do, and we want to see if we're getting it all. I'm having a hard time, and like I said, I have no way of posting bond, Your Honor. And
Mr. Miranda, it sounds like you have a potentially very compelling case for modification of the conditions of release following today's date, but without sufficient information regarding all of these details, which you would be able to compile and present to your public defender for assistance. There's just limited information for me to go on, given the extensive history of repeated offenses that's evident in your record, and without more information about these matters. That's why I'm doing what I'm doing today. To order at this time, but please talk to your public defender's office or your public defender as soon as you can about getting a modification. Okay. You're excused. Thank you, sir.
This is going to be set out here. There's not this to see you. Stay here. If not, if it's I'll be able to file this stuff. For the time to get here. Okay.
Good morning, sir. Can you state your name, please?
Good morning, Anthony Michael Rene Molina.
Give me one moment, Mr. Molina, before we proceed. I just want to take a look at something in your file.
Okay.
Okay. Mr. Molina, you're being seen today on a few offenses. First, it's child or vulnerable adult abuse, which is a felony offense, as well as 2 misdemeanor counts of domestic violence / assault and reckless driving. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel, and there is counsel seated next to you. In review of the pretrial services recommendation, court notes that the victim in this matter does not object to the defendant's release and provided some additional information. Any additional record from the state?
Your Honor, this was an absolutely wanton and unnecessary incident. This person allegedly snatched the child from the child's mother, from her car, put it in his car, and then decided to spin donuts in a parking lot with this poor kid in the back seat. This is incredibly dangerous, incredibly unnecessary, incredibly wanton. $10,000.
And from defense?
Yes, Your Honor. We would highlight that he does not have a flag on him. He scored a 3 on both the NCA and FDA scales. We would also add that Mr. Molina is a lifelong resident of Tucson. He does have family support and full-time employment. Any housing issues as far as children can be addressed. It appears in pretrial services workup. And we would also just highlight the victim is not objecting to his release. We would ask for release pretrial services.
Okay. Mr. Molina, what the court's going to do at this time, the court has pretty specific conditions of release that I want you to listen carefully to. At this time, the court is going to, and this is primarily based upon the victim's input, the court's going to order releasing you to pretrial services, but please pay careful attention to these conditions of release. You're not to drive without a valid license. You're not to have any alcohol or illegal drugs, no acts of domestic violence, follow any monitoring or treatment as directed by pretrial services. You're not to have any contact with the individual Aisha Leon, who I've spelled her name spelled in 2 different ways, so I'm putting both spellings in the orders. You're not to go to her residence or workplace. Court will order that the Pima County Public Defender's Office will represent you. And specifically the court, this is what I want you to listen carefully to, as an additional condition of release, you're to attend, and this will be written down for you, 3 sessions of the Dad's Den parenting group with Parent Aid, which is a local organization here providing parenting instruction to families. Their contact information is listed in the order. I believe that this parenting instruction will assist you in not repeating the alleged offenses that you're being accused of. And I think it'd be beneficial for you to do that. So that is an additional condition. If you do not abide by any of these conditions, you can be declared to have violated these conditions of release and could be reincarcerated. Does that make sense?
Yes, it is.
Because you're being released on today's date, for the reasons stated, court will set the next hearing July 22nd, 2025, 1:30 p.m. at the Pima County Justice Court for a preliminary hearing. Failure to appear at future court hearings could result in a warrant being issued. So make sure that you go to future hearings. And because you're being released, it's possible that the preliminary hearing will be moved out to a different date. So just check with your assigned public defender about that, okay?
Okay.
And you're excused. Thank you, sir.
Thank you.
Okay.
Thank you. You wanna go?
Humphre's. Huh? Yeah.
Those cards are
Good morning, sir. Can you state your name, please?
William Alfred Humphreys.
Can you state your first name again, sir?
William, William.
Thank you very much. So, Mr. Humphreys, you're being seen today on 2 felony counts of possession of drug paraphernalia and possession of a dangerous drug. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel, and there is counsel seated next to you to assist you on today's date. State has recommended that bond be set in the amount of $7,500 with release to pretrial services if bond is posted, and that this recommendation is in lieu of requesting no bond. Would the state like to elaborate?
Your Honor, in this matter, he's already out. He's a 4 and a 5 out of 6, respectively. His pending felony charges. The only reason we're not is the nature of the current charges. State submits otherwise.
Thank you. And defense?
Yes, Your Honor. I would start by just highlighting that as to the drug possession charge, I believe the interim complaint is deficient for probable cause. It does not list a NIC test for any of the white substances. And as for fentanyl, there's no observations that anything may have been fentanyl or something couldn't have been tested. So as to the possession charge, I would argue there's no probable cause. We would additionally add that Mr. Humphreys is a lifelong resident of Tucson, and that he did not get a flag on the NVCA scale. We would ask for a nominal bond, with the understanding that these are drug charges and Mr. Humphreys is steps eligible.
Mr. Poston, do you want to be heard as to the request for finding of no probable cause as to the possession charge?
Your Honor, the state's reviewed it and believes it is sufficient on its face. An officer shouldn't be required to go through the rather pedantic stuff of spouting the magic words. They know fentanyl when they see it.
Okay. At this time, the court will find that there's no probable cause as to the charge of possession of a dangerous drug based upon the lack of statement in the probable cause statement indicating that upon training or experience or similar terminology identifying what the crystalline substance and blue pills were. Mr. Humphreys, that doesn't necessarily mean you won't later be charged with it if there's an amended statement or a new complaint that's issued, but for the time being, I'm finding that there's no probable cause and that specific charge will be dismissed on today's date. However, the court is going to sustain that there's probable cause as to the charge of possession of drug paraphernalia. On that current charge, the court will order that bond be set in the amount of $2,500, cash or secured, with release to pretrial services if bond is posted. And the court is instituting bond primarily because there was a separate pending felony offense. The court could hold you without bond, but the court is opting instead just to set a lower bond as a result. Court will order no alcohol or illegal drugs, monitoring the treatment as directed by pretrial services, and Joseph D. Roberto is assigned to represent you as your attorney. Your next hold on just one moment. Your next hearing is July 14, 2025, 1:30 p.m. at the Justice Court for a preliminary hearing. Was there a question, sir?
I'll ask my lawyer. Thank you.
That's fine. One moment as I type something in your file really quick, and I'll indicate that the dismissal for the dangerous drug offense, and that would be under 133407, that dismissal is over the objection of the state. Okay, Mr. Humphreys, in general, just make sure that you appear at future proceedings. Failure to appear can result in a warrant being issued. Anything additional from anybody before we conclude?
Is there a reason? Is there a reason that Joe DeBrito is? He ghosted me.
Okay, with that, we'll go ahead and excuse Mr. Humphreys. Thank you, sir.
Thank you.
Good morning, ma'am. Can you state your name, please?
Melissa Carbol.
Ma'am, you're being seen today on initial appearance for organized retail theft and theft, which are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel, and there is counsel seated next to you to assist you. State is recommending that bond be set in the amount of $7,500 with release to pretrial services if bond is posted. We did previously see a co-defendant here today on the same matter. Any additional record, Mr. Poston?
Your Honor, she's an NVCAS. She's a 6 and a 4, and statement correct. It's narrative from April 2025 to present, not 2005. Excuse me. This defendant has allegedly stolen over $5,000 in merchandise from one particular location within the mall. She's given a false name in the past. State considers her a risk and also a risk to the community in that those of us who pay for our goods have to absorb the increase in cost from people that steal. And she's also given a false name, which speaks to a flight risk. Thank you.
Okay, thank you. And for the defense?
Yes, Your Honor, we just highlight this is a non-violent offense, that Ms. Carbol is a lifelong resident of Tucson, and she does have stable housing and supports. We'd also add that she is unemployed and has no other discernible means to pay a higher bond. So we ask for release to pretrial services or the alternative, a more nominal bond.
So at this time, the court does note that in review of the pretrial services report, as opposed to the other co-defendant who was a 4 and a 3 on the NCA and FTA scales, we have this defendant as a 6 and a 4, which is higher on both scales. Some of the circumstances presented for the other co-defendant do not appear to exist with this defendant. And there is a lengthy criminal history that the court is observing dating back to 1999, some of which are for similar offenses. So for all those reasons, the court will order that bond be set in this matter in the amount of $5,000 cash or secured with release to pretrial services if bond is posted. Conditions of release will include monitoring or treatment as directed by pretrial services, not for the defendant not to go back to the incident location. The court will appoint the Pima County Legal Defender's Office to represent the defendant. And then, so ma'am, your next court date in this matter is going to be a preliminary hearing set July 14, 2025, 1:30 p.m. at the Justice Court. That's July 14, 1:30 p.m. Make sure that you appear at that hearing. If you do post bond before that hearing, you still need to attend. And that'll be your next court hearing. In this case, failure to appear can result in a warrant being issued. Any questions before we conclude? Okay, with no questions being apparent, ma'am, you're excused. Thank you. Hold on, actually. One moment, we've got a city case 4-2, so we're gonna move on to that. So give me one moment to get that file. Okay. Okay, so ma'am, you're also being seen today on a charge of looks like it's a warrant that was issued for failure to appear on or around, the warrant was issued February 28, 2024 for the crime of leaving the scene of an accident. That's Tucson City Court. At this time, the court will set bond in the amount of $50 cash or secured in order to secure appearance. And court will appoint the city public defender's office to represent the defendant. And next court date in the city court will be July 11, 2025, 1:45 p.m. with Judge Cranshaw. That'll be for a video review. And then if you do happen to post bond, then the hearing would be set August 4th, 2025, 2:30 p.m. So if you're post bond before the video review, then that'll be your next court date, but do check with the city court about attending all the matters that you need to attend. Failure to appear can or your arrest. Any questions on this one before we conclude? Okay, with that,
No.
you're excused. Thank you, ma'am. Good morning, ma'am. Can you state your name, please?
Vanessa Gatlin.
Gatlin, you're here on two matters today. The first one we'll talk about is failure to appear for Superior Court initial appearance and arraignment. The warrant was issued April 3rd, 2025 by Judge Knotzer. There was initially an arrest warrant also that was issued out of the Justice Court for failure to appear. Well, actually, that'll be the second thing we talk about. So the first one is the warrant issued out of Superior Court for failure to appear. The state is recommending on that charge that a bond of $500 be that remain in order to ensure appearance. Any additional record, Mr. Poston?
No, Your Honor, state merely repeats the warrant, makes no recommendations.
And then for the defense.
Yes, Your Honor. Ms. Gatlin is a lifelong resident of Tucson with stable housing and support. What was apparent from the pretrial services workup is that she was not aware of the summons, that it did not make it to her. And what she has just expressed to me is that she has multiple cases going on, specifically in the family court, that she is participating in, that she has support for. She has been in regular contact with, sorry, what's his name again? William Sharp. William Sharp over in the family court. She does have a CPS visit later today. And for all these circumstances, I don't believe that she poses a future risk for failure to appear. So we'd ask for at least pretrial services.
Ms. Gatlin, are you on my family court caseload?
I don't think I'm on yours.
Yeah. I didn't instantly recognize your name, which I usually would. We had another individual today who was on my family court caseload, so doesn't appear to be the same circumstance. Just wanted to double check. Okay, so in assessing what the court's going to be doing on this, the court does find persuasive the pretrial services narrative indicating that there may have been lack of notice regarding the obligation to appear. So Ms. Gatlin, the court's going to order that you be released on your promise to appear.
I will appear. I promise.
But as it appears, we've got 2 failures to appear right now, and I know that there are a lot of court cases happening for you. I'll just take it all at one. Do make sure that you keep in touch. I'm sorry, that you make sure that you appear at everything, because things can start getting a lot more complicated if you have a recurrent history of not appearing. Okay.
For sure. I will make sure of that. Thank you so much.
So the court will go ahead and do that in the court. What I want to make sure to see is, was there? Okay, so that'll be released on promise to appear. That hearing will occur for the Superior Court. You'll have then an arraignment and initial appearance. That'll be set July 9, 2025. So July 9, 2025, 1:30 p.m. at the Superior Court. It'll be on the 3rd floor.
Okay.
And the court will affirm appointment of the Pima County Legal Defender's Office. And do make sure that you appear. Failure to appear can result in another warrant being issued, and then the next judge who would pick you up on or see you on that may not be as lenient. Okay.
Yes, for sure. Thank you so much for your leniencies.
And for the other Justice Court matter, this is for a warrant that was issued by Judge Garza back in later and also in April of 2025. The court, these are for offenses for shoplifting and also for driving on a suspended license. The court will order releasing you on your promise to appear. Again, do make sure that you go to these hearings. Failure to appear can result in a warrant being issued. The next judge who reviews that may not be as lenient. Court will set your next court date in the Justice Court matter, July 29, 2025, 9:30 a.m. for a case management conference. So that's July 29, 2025, 9:30 a.m. with Judge Garza at the Justice Court. Court will affirm prior release conditions for those offenses. And again, I've said it a few times to Ms. Gatlin, please make sure that you appear at all of these hearings, July 9 and July 29. Failure to appear can result in a warrant being issued. Any questions at this time?
No, thank you so much.
You're welcome. With that, we will go ahead and excuse you.
Awesome. Same. Okay, the same. Okay, thank you so much. Oh, that was sorry.
Good morning, sir. Can you state your name, please?
County Dean Lyles.
Mr. Lyles, you're here today on a couple of counts of possession of narcotic drug and possession of drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel on these felony charges, and there is provisional counsel seated next to you to assist you today. State is recommending bond be set in the amount of $2,500 plus release to pretrial services if bond is posted. Any additional record from the state?
No, Your Honor.
And for the defense?
Yes, Your Honor, we'd highlight this is a drug case. It is steps eligible. We would also highlight that Mr. Lyles has been a resident of Tucson for 30-something years. He does have stable housing and family support. As noted in the pretrial services workup, he does have disabilities that affect him daily. Transportation is available for all those reasons. Oh, and then he has no flag on the NVCA scale. So for all those reasons, we would ask for release to pretrial services, or in the alternative, a far lower bond.
Your Honor.
Yes, go ahead.
Just to be clear, looking at whether or not this individual may be eligible for steps, I am looking at the pretrial service, and in this case alone, there is nothing there. However, it looks like he's on a warrant, which means he may or may not be available. And when looking at his history, he has 2 priors for drug paraphernalia or drug possession. It does not look like he's going to be steps eligible here.
Okay, so in review of the file, the court shows that there are those 2 prior offenses. It appears that in each instance, probation was revoked, which affects the court's determination of whether simple release to pretrial services would be sufficient. It does appear there's some sort of warrant that maybe exists at this time, although I don't have any notice of any specific hold that's on Mr. Lyles right now. What the court will go ahead and do is the court is going to order that bond be set in the amount of $1,000 cash is secured with release to pretrial services if bond is posted, for conditions of release, no alcohol or illegal drugs, monitoring or treatment as directed by pretrial services, and then also that the defendant shall not go back to any incident location. Pima County Legal Defender's Office is appointed, and the next hearing for Mr. Lyles will be July 14, 2025, 1:30 p.m. For a preliminary hearing, Mr. Lyles, even if you do post bond, make sure that you appear at that hearing, July 14, at Justice Court, and then failure to go to any future court hearings can result in a warrant being issued for your arrest. Do you have any questions, sir? Okay, then you're excused. Thank you, sir.
With this number, if it is someone out here, but that's not answers happening. Get out. Yeah, I guess those do.
Good morning. Good morning, sir. Can you state your name, please?
Michael Gary Long.
Mr. Long, we have you here today on 2 counts of shoplifting and drug paraphernalia possession. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel, and there is counsel seated next to you to assist you. State is recommending bond be set in the amount of $2,500 with release to pretrial services. Any additional record, Mr. Poston?
Not here, Your Honor, other than to note the 4-6.
Okay. And from the defense?
Yes, Your Honor, we would highlight that Mr. Long has been a resident of Tucson for over 40 years. He does have stable housing, although he does not know his address. He has informed me that he is unemployed. He has no monetary ability to pay a bond amount, especially not $2,500. We would ask for release to pretrial services or
Well, in review of Mr. Lyles, not Mr. Lyles, Mr. Long, excuse me.
Sorry.
I don't see any felony criminal history of note.
Yes, correct. That's correct, Your Honor. I also meant to add no felony history and no flag on the NVCA scale. Sorry about that.
It's very important. I will come to the court, Your Honor.
You do have the failure to appear scale as a 6. Mr. Poston, do you know why that failure to appear scale is so high?
I have the same information the court has, Your Honor.
It's because I had a lot of like driving on suspended and it was so petty. I missed court and stuff. So that's what my failure of appeals were. Failure to appears were. It was nothing like felony worth, you know. I'm definitely going to show up and take care of that, sir. I don't have any felonies. Like I don't want to have a felony.
Okay. So what the court will go ahead and do, I think given the specific nature of the alleged offense here, one moment, I'm just reviewing a couple things, because we also have a city court case that we need to address after this. Okay, at this time, what the court will just do, Mr. Long, I'm going to give you a chance on this.
Thank you.
Court can order that you be released to third-party supervision of pretrial services, not to engage in the use of alcohol or illegal drugs, monitoring or treatment as directed by pretrial services. If there's any stated victim in this matter, that no contact with that victim, and also that to not go back to the incident location, the court will order appointing the Pima County Legal Defender's Office to represent you. Folks often do not comply with checking in with pretrial services, so Mr. Long, don't be one of those people, because that can also be a violation of your conditions of release, and then we're all right back where we are right now. Your next court date is going to be July 22nd, 2025. That'll be at, I think it's 1:30 p.m. And that will be, so 1:30 p.m. on July 22nd at the Justice Court. That hearing may be pushed out because you're being released. So do get in contact with your legal defender to make sure what the next court date's going to be. So the court will go ahead and move on from that one, and we'll go to the city court case now. So in the city court matter, we have like there was a shoplifting matter from March of 2025. Court will order release on promise to appear. Mr. Law, make sure you go to the city court matter as well. If you do not go, then a warrant could issue for your arrest.
Yes, sir.
I'm going to take you at your word today that you're going to appear and do everything you need to do. If not, you may be picked up, and then the next person who sees you may not be as lenient, okay?
Yes, sir. Thank you, Your Honor.
So we'll go ahead and set a pretrial hearing, July 31st, 2025, 9:00 a.m. That'll be at the city court with Judge Maldonado. So July 31st, that's the second court date that you have. Make sure that you appear on that. And court will order as part of this shoplifting matter that you not to go back to the incident location.
Yes, sir.
Okay, with that then, you we should be all set. You're excused. Thank you, sir.
Thank you.
Get this number, call this pretrial. This number, call and they'll get the wires.
Thank you.
There's a bunch of paperwork in here that might be yours. I'm not sure. Do you want to look through this first and then give it back to me? Yeah.
Lawrence Moreno.
Okay. Morning, sir. Can you state your name, please?
My name is Lawrence Moreno.
Thank you. Mr. Moreno, we have you here today on an initial appearance for domestic violence, essentially aggravated assault charge under 13-1204A7. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel, and there is counsel seated next to you to assist you. I do also understand that we may have a victim in this matter who's on Microsoft Teams. If any victim would like to make a statement to the court, you're welcome to. So if you're in that category, if you please speak up on Microsoft Teams. If you don't say anything, that's fine too. I'll just assume you don't want to make a statement. So I'll wait a moment. Okay, not hearing anything from the purported victim who's on Microsoft Teams. We'll go ahead and proceed. State is recommending that bond be set in the amount of $15,000 plus release to pretrial services if bond is posted. Mr. Poston, any additional record?
He's an NVCA. Yes, he's a 4 and a 6, has 2 pending cases, both DV, and has violated an active OP. And when he was called out and told to leave the residence, he decided to become violent. State submits.
And then for the defense?
Yes, Your Honor, we would highlight that while this is listed as a violent offense, a domestic violence aggravated assault, there was no injury sustained by the victim. They also, from the pretrial services indication, do not object to his release. We would also highlight that Mr. Moreno has been a resident of Tucson for upwards of 30 years, and he has no prior felony history, and there is a concern of underlying mental health conditions at play. We would ask for a release to pretrial services or in the alternative, personal health life.
But Marita, if you want to speak up and let them know if you don't want to press any charges, that'd also be great.
All right, sir, I'll ask you not to speak to the victim. If you do it again, I'm going to have you leave the proceeding.
Oh, I'm so sorry, Your Honor. I'll just be quiet. Pretrial services. I'll do that.
Okay, so to be honest with everybody, this case has a very confusing fact scenario. We have multiple pending city court cases, which we're going to talk about in just a moment, involving the alleged victim for the felony matter. There is indication of violation of orders and existing order of protection. We have pretrial services and information indicating that the alleged victim is not objecting to the release of the defendant. The information presented in the probable cause statement also indicates that the defendant allegedly went to the victim's residence and was allowed to be in the residence to stay overnight, and then when asked to leave that's when things got combative, which presents a confusing fact scenario for the court. So give me one moment to continue looking at this matter just a little bit more. Okay. In review of the court also has a narrative issued from the citation that was issued on July 1st, 2025, which indicates that the defendant was advised not to go to the residence, but did anyways. I think that, coupled with the statement from the defendant on today's date, asking the defendant to advocate for his release, that compels the court to order that the court will institute bond in this matter in the amount of $7,500 cash is secured, with release to pretrial services if bond is posted.
I can.
This is also informed by the multiple incidents asserting that there have been violation of protective orders. So conditions of release would be no alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons, monitoring or treatment as directed by pretrial services, no contact with the alleged victim, Maritza Chavez, not to go to her residence or workplace. Pima County Public Defender's Office is appointed to represent the defendant. Preliminary hearing will occur on July 14, 2025, 1:30 p.m. So, sir, make sure that you go to the hearing on July 14, 2025. Failure to appear can result in a warrant being issued.
I will.
Let's go ahead and move forward to the city court matter. City court matter is related to failures to appear for disorderly conduct, 2 counts, as well as interfering with a judicial proceeding, for violating a court order. Additionally, there's a new charge of interfering with a judicial proceeding and criminal trespass. So these are misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. The court is going to institute bond in this matter in the additional amount of $500 cash or secured. Court will order no alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons, no contact of any kind with the individual Maritza Chavez. And then not to go to the victim's residence or workplace. Court will appoint the city public defender's office to represent the defendant. Okay, next hearing then in the city court matter will be with Judge Million. That'll be on July 9, 2025. That's at 1:30 p.m. That's with Judge Million. And then, sir, make sure you also go to that hearing regardless of whether you post bond. I have to go to that one as well. Okay. Any questions before we conclude?
So I'm gonna be held to my court date, correct? Without bond?
You have a bond set in both cases. The next court dates are July 9 in the city court case, July 14 in the justice court case.
So I mean, I won't be able, that possibly won't be released.
It's somebody will be able to see it.
Your Honor, we have another justice court case as well.
For Mr. Moreno?
Yes, Your Honor.
I don't show that in my system.
Yeah.
Yeah. So I show that we have.
You're correct, Your Honor.
I'm sorry?
That is it. You are correct.
Okay. All right. Sounds good. Okay. You're excused, sir. Thank you.
Okay. Thank you. Love you. Thank you, Your Honor.
Thank you. Okay. Good morning, sir. Can you state your name, please?
Renault.
Mr. Renault, we have you here today on a felony offenses of we've got you here on 2 felony counts, 2 misdemeanor counts. We have a felony count of cruelty to animals, a felony count of intentional cruel mistreatment of an animal. We have a misdemeanor charge of harm or death caused to a work or service animal, and a misdemeanor charge of cruelty to animal. These are both felony and misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. And you do have a right to counsel, and there is counsel seated next to you to assist you on today's date. State is recommending that bond be set in the amount of $5,000 plus release to pretrial services. Any additional record, Mr. Poston?
No, Your Honor.
And from the defense?
If you have one moment with Mr. Renault.
Yeah, that's fine.
Okay, Your Honor.
Go ahead.
We would begin by highlighting that Mr. Renault is level 1 nonviolent. He has no flag, and he scored a 3 and a 2 on the NCAA and FTA scales, respectively. He has been a resident of Tucson for over 20 years, and he has no prior felony history. The pretrial services workup in the intern complaint briefly kind of skimmed over this and highlighted the fact that this may have been a mistake related to Mr. Renault's disabilities. He has been diagnosed with bipolar and manic depressive. He does have ADHD. And he's informed me that he was recently hit in the head. He does have a mark on his head. That prevented him from getting any any level of sleep for multiple days. It does sound like what happened here may have been an honest accident. We would ask for, given his narrative, the narrative in the interim complaint, and his lack of felony history, release to pretrial services. Or
Any response, Mr. Poston?
Your Honor, can you hear me? I'm getting a horrible connection right now.
I can hear you.
The state submits on the written record.
Do we know if the animals involved in this survived?
We do not.
Okay. At this time, the court will order, I really would like to know the status of the animals, but I don't have that information at this time. I know that they were certainly injured based upon the allegations, but I don't know anything further from that. Given all the circumstances presented, the court will order releasing the defendant to the third-party supervision of pretrial services. Mr. Renault, make sure that you check in with pretrial services. It is a common way for folks to violate their conditions of release, that they do not check in. You are you're not to go back to any incident location as well, and your counsel will be appointed to the Pima County Public Defender's Office. Next court date for you will be July 22nd, 2025 at 1:30 p.m. for a preliminary hearing. Since you're being released on today's date under third-party supervision, that hearing on July 22nd may be moved, and so check with your public defender about that. Otherwise, do you have any questions on today's date?
I have a question. Can I ask you first?
Yeah, absolutely. So Your Honor, the incident location is where Mr. Renault's trailers are. It's where the bulk of his utilities where he lives are. So we just asked to be allowed to return for the purpose of getting those materials in his trailer.
Judge?
Yes.
Considering the nature of this, I don't know if there's any value gained by the court prohibiting it from returning to the location. Anything forensic is either collected or spoiled at this point. If that's where he lives and he's the only person that lives there, the state has no objection to him returning.
Okay, then I'll go ahead and order removing that prohibition from the conditions of release. Anything additional from any party?
That's
We've got to keep moving with the calendar, so let's.
Apologies, Your Honor.
Okay, anything additional then?
No.
Okay, then you're excused. Thank you, sir.
Thanks.
Good morning, sir. Can you state your name, please?
Good morning, Cyrus Robertson.
Mr. Robertson, you're here today on a number of charges. Those charges include 4 felony counts. You have criminal impersonation, providing a false ID, forgery with a written instrument, taking the identity of another, and obstructing a criminal investigation. You also have misdemeanor offenses of DUI, DUI with BAC of 0.08 or more, making a false report to law enforcement, and obstruction and refusing to provide your true name. As to the felony offenses and also the misdemeanor offenses, you do have a right to remain silent. Anything you say can and will be used against you. As to the misdemeanor offenses, as to the felony offenses, you also have a right to assistance of counsel, and there is a counsel there to help you on today's date. State is recommending bond be set in the amount of $3,500 plus release to pretrial services if bond is posted. Any additional record, Mr. Poston?
No, Judge.
And for the defense?
Yes, Your Honor. Just that Mr. Robertson is a level 1. This is a nonviolent offense. Had no flag on the NVCA scale. He also scored a 2 and a 1 on the NCA and FTA. He is a lifelong resident of Tucson. He's obviously very young. He does have a stable residence with stable employment. It sounds like as a supervisor role at Safeway. Additionally, he has no criminal history whatsoever prior to this case. We would ask for release of pretrial services.
Okay. Mr. Robertson, if you had any prior alcohol, drug, or DUI offenses, the court would absolutely be holding you right now. But under the circumstances, what I see from this is that it sounds like you made a series of extremely stupid decisions, which I'm also factoring in. It might be attributed to your age. You may have panicked. Nonetheless, I'm going to give you an opportunity here to avoid further incarceration, but do be mindful that any violations of these orders, these conditions of release could result in you being reincarcerated, and that the next person who takes a look at this will not be as lenient. Does that make sense, sir?
Yes, sir, Judge.
Okay. At this point, then, the court will order that you be released to third-party supervision of pretrial services. You're not to drive without a valid license, no alcohol or illegal drugs. Follow the monitoring of treatment as directed by pretrial services. The Pima County Public Defender's Office will be appointed to represent you. You have your next court date, July 22nd, 2025, 1:30. That's at the Justice Court for a preliminary hearing. Because you're being released today, that preliminary hearing date may be moved, and you may not have a court date on that date. Keep in touch with your public defender to get your next court date. If you do not appear at future proceedings, you could be a warrant could be issued for your arrest, and you could be rearrested. Any questions before we conclude?
No, Judge.
Okay, then you're excused. Thank you, sir.
Thanks. God bless. Get that number to call in a day or two. You'll be here chatting and next day checking with pretrial services by calling. Okay, thank you.
Good morning, sir. Can you state your name, please?
Jake Sanchez.
Mr. Sanchez, we have you here today on a few felony matters of assuming the identity of another, possession of drug paraphernalia, possession of a dangerous drug, and also possession of a narcotic drug. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel, and there is counsel seated next to you to assist you. The state is recommending that bond be set in the amount of $7,500 rather than asking for no bond. Any additional record, Mr. Poston?
No, Your Honor.
And for the defense?
Your Honor, understanding that there is a probation hold and that the state could hold Mr. Sanchez without bond, we would just highlight that he does have housing available with his sister and doesn't seem to be enjoying some employment prospects. We would ask for a more nominal bond than $7,500, but we would object to a bond.
Okay.
I just informed that Mr. Sanchez does indeed have a job.
Okay. Looking at, there appears to be an extensive criminal history record for Mr. Sanchez, although some of it is over 10 years. There is a 4 and 4 on the NCA and FTA scale for the pretrial services report. Looks like there may be a probation violation warrant that's already indicated, and that regardless of the court's decision on bond, that Mr. Sanchez will likely be held. Given all these circumstances, and especially given the amount of substances that were in Mr. Sanchez's possession, the court will accept the state's recommendation bond of $7,500 with release to pretrial services if bond is posted. And the court will further order no alcohol or illegal drugs, follow monitoring or treatment as directed by pretrial services. Court will order appointing the Pima County Public Defender's Office to represent the defendant. Preliminary hearing will be set July 14, 2025, 1:30 p.m. at the Justice Court. Mr. Sanchez, do make sure that you appear. Failure to appear can result in a warrant being issued for your arrest. Any questions, sir, at this time before we conclude?
It's posted. So what is it? Post all that. We can down the rest of the platter. Yeah. Great.
Good morning, sir. Give me one moment, then we'll get to your case. Okay. Sir, would you go ahead and state your first and last name, please?
Brandon Shaughnessy.
Mr. Shaughnessy, we have you here today on a couple of charges of dangerous drug possession and drug paraphernalia possession. You have a right to remain silent. Anything you say can and will be used against you. You do have a right to counsel. There is counsel seated next to you to assist you. State is recommending that bond be set in the amount of $5,000 rather than ordering or requesting no bond. Do you want to be heard, Mr. Poston?
No, Judge.
Okay. And then for the defense?
Yes, Your Honor, we would just highlight this is a nonviolent case. He did not score, he does not have a flag on the ECBA scale. He has been a resident of Tucson for 22 years and does have stable housing available to him. Understanding the state could move forward with a no bond hold, we would just ask for a more nominal bond, which Mr. Shaughnessy may be able to.
Give me one moment. Okay, court at this time will order that bond be set in the amount of $1,000 cash. Secured with release to pretrial services. The bond is posted. Conditions of release: no alcohol or illegal drugs. Follow monitoring or treatment as directed by pretrial services. Pima County Public Defender's Office is appointed to represent Mr. Shaughnessy. Next court date in this matter will be on July 22nd, 2025. Sorry, July 14, 2025, 1:30 p.m. for a preliminary hearing at the Justice Court. Mr. Shaughnessy, do make sure that you appear. Failure to appear at the July 14 hearing could result in a warrant being issued for your arrest. Do you have any questions?
Never done it. Never done it. So, saying this,
Okay, I understand, Mr. Shaughnessy. If you want to modify these conditions, you will be able to pursue that through your public defender. Otherwise, if you have no other questions, you are excused. Thank you, sir.
Shaughnessy.
Good morning, sir. Can you state your name, please?
My name is Francis David Trujillo.
Mr. Trujillo, we have you here today on felony counts of burglary in the second degree and domestic violence, custodial interference. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There is counsel seated next to you to help you on today's date. The state is recommending bond be set in the amount of $5,000 with release to pretrial services. And any additional record, Mr. Poston?
No, Your Honor.
And then for the defense?
Yes, Your Honor. Mr. Trujillo was listed at level 1 of the pretrial services workup. This is a nonviolent offense. He does not have a flag, and he's scored as a 2 in both the NCA and FTA scales. We'll also highlight that Mr. Trujillo is a lifelong resident of Tucson with stable housing and full-time employment. As far as the actual charges go, there were no injuries reported, and there was no actual theft of property. In this case, we would ask for release to pretrial services.
Can I get a second here?
And if I can have just one very brief moment.
That's fine.
Right?
Yeah. The only other thing that I would add is that despite his employment, Mr. Trujillo is currently under financial hardship, just given his current situation and juxtaposition in life. So we would still ask for release to pretrial services.
Well, I do tend to agree with the state, or I'm sorry, the defense, that there wasn't any sign of injury or any such offense in that way. It seems like burglary is being charged by virtue of the way in which he entered the home, but not in a manner that necessarily caused any damage to the home. I think that also being said, the court is concerned regarding the prospect of having future instances such as this arise unless there are specific conditions in place. And so in weighing basically whether to hold Mr. Trujillo to make sure it doesn't happen versus having specific orders in place, what the court's going to go ahead and do is lean in the favor of the court will order releasing the defendant to the third-party supervision of pretrial services. However, there are going to be very specific conditions of release. Court will order that there be no alcohol or illegal drugs by the defendant, no acts of domestic violence, no firearms or weapons, monitoring or treatment as directed by pretrial services, no contact with the individual Julia Higuera, not to go to a residence or workplace. I don't see an attorney highlighted in my form here. Who were you appointing on this one? Mr. Trujillo?
I'm sorry. Oh,
Trying to figure out whether who your attorney is going to be, if it's public defender, legal defender, or legal advocate.
for now, a public defender.
They're
Oh, I see. I'm so sorry. There was a retainer. That's lawyer as well.
While we're waiting on that information, the court is also going to order, though, that there be no contact with the minor child in common unless authorized by an existing court order.
Understood.
So if you need to pursue contact with this child and there's not an existing court order in effect, then the next stop is to family court to go ahead and get one of those orders. But until that happens, then no contact, no going to the house to try to have contact with the child. It needs to be done in the proper way.
I do want to mention, Your Honor, that I'm in the process, and I was in the process of getting all that taken care of, documenting prior instances of violence from the defendant or the victim in this case. There's multiple documented evidence of this. She did also have to go to therapy regarding some of this on her own volition.
Okay, and some of that may be more relevant to another proceeding, but that is preserved for the record. So at this time, then, the court will order appointing the Pima County Public Defender to represent you in this matter. Next court hearing in this matter, July 22nd, 2025. That'll be at 1:30 p.m. at the Justice Court for a preliminary hearing. Because you're being released, that preliminary hearing may be moved to a later date. Just check with your public defender to get updates on your court hearings and the dates of those hearings. Failure to appear at future hearings could result in warrant being issued for your arrest. Do you have any questions, sir, at this time?
Regarding thank you so much. I really appreciate your understanding in this matter, Your Honor.
Understood. You're welcome. And with that, then you are excused. Thank you, sir. With that matter, it looks like we're all done for today. Thank you, Mr. Poston. Thank you for in pretrial services. We're going to go and conclude today's stream.
Thank you, Your Honor.
Good day.
Thank you.